It sounds like something that would completely flip the balance of power overnight. A shift so significant that tenants across the country might suddenly find themselves with protections they didn't even realize existed. But when you look closer, what appears to be a sudden change is often the result of years of legal challenges, court decisions, and evolving interpretations of housing law. And in some cases, what people think landlords can't do anymore was never fully allowed in the first place. But here's the question. Has something actually changed in the law? Or are courts simply enforcing rules that were always there but rarely challenged? I want you to think about that carefully and share your answer in the comments below. Now, to understand what's really happening here, we need to step away from the headline and start with the legal foundation of landlord-tenant relationships. Because this area of law is built on a combination of statutes, contracts, and constitutional principles. According to widely recognized legal frameworks, the relationship between a landlord and a tenant is primarily governed by lease agreements and state-specific housing laws. These laws define what landlords can require, what tenants must follow, and how disputes are resolved. But there's something critical that often gets overlooked. Even though lease agreements are contracts, they cannot override certain legal protections. In other words, just because something is written in a lease does not automatically make it enforceable. According to established legal doctrine, courts have consistently held that contracts cannot violate statutory protections or fundamental rights. And this is where many disputes begin. Because in practice, some tenants may assume that whatever is written in a lease must be followed without question. At the same time, some landlords may rely on provisions that are not fully aligned with current law. This gap between perception and legal reality is often where cases emerge. Now let's talk about what may have triggered the kind of headline we're discussing. In situations like this, changes are usually driven by one of three things: a new law passed by a legislature, a court decision that reinterprets existing law, or enforcement actions that clarify how rules are applied. According to official legal processes, courts play a key role in interpreting landlord-tenant law, especially when disputes arise over rights such as eviction, property access, rent control, or tenant protections. And when a court issues a ruling, it doesn't just resolve one case. It can also influence how similar situations are handled moving forward. That's how legal standards evolve. Now, let's move into a typical scenario that often leads to headlines like this. A tenant challenges a landlord's action, perhaps related to eviction procedures, entry into the property, restrictions on use, or conditions imposed in the lease. The tenant may argue that the landlord's conduct violates state law or statutory protections. The plaintiff alleges that their rights were restricted beyond what the law allows. On the other side, the landlord's legal position typically states that their actions were permitted under the lease agreement or existing regulations. This is where the court steps in. Because the court's role is not to favor one party, but to interpret the law and determine whether the conduct in question is legally valid. And sometimes, the outcome reveals something important: that certain practices, although common, do not hold up under legal scrutiny. In my legal analysis, this is often the moment where people feel like everything has changed, even though the underlying law may have existed for years. What changed is not always the rule itself, but how clearly it has been enforced or interpreted. Now let's bring in the constitutional layer, because this is where things become even more interesting. While landlord-tenant law is mostly governed by state statutes, certain constitutional principles can still apply, especially when it comes to due process. Under the 5th and 14th Amendments, individuals cannot be deprived of property without due process of law. In the context of housing, this often relates to eviction procedures. Courts would likely examine whether tenants were given proper notice, whether they had an opportunity to respond, and whether legal procedures were followed correctly. If those standards are not met, actions taken by landlords can be challenged, even if they believed they were acting within their rights. Additionally, there are situations where Fourth Amendment considerations may arise. For example, if a landlord enters a property without proper notice or legal justification, courts may evaluate whether that action interferes with a tenant's reasonable expectation of privacy. This is not always straightforward, but it is part of the broader legal framework. Now let's go deeper into the idea of what landlords can't do anymore. One interpretation is that courts are reinforcing limits on certain actions, such as self-help evictions, unauthorized entry, or lease provisions that conflict with statutory protections. Another perspective raised in legal discussions is that these limitations have always existed, but were not consistently challenged or enforced. So, when a ruling brings clarity, it can feel like a sudden shift. But legally, it may simply be a reaffirmation of existing rights. Now let's talk about enforcement, because this is where theory meets reality. Even if a law is clear on paper, its impact depends on how it is applied. Tenants must be aware of their rights to assert them. Landlords must understand their obligations to comply. And courts must interpret disputes when they arise. This three-part dynamic shapes how landlord-tenant law functions in practice. Now consider the real-world impact. For tenants, increased clarity can provide a stronger sense of security. They may feel more confident in challenging actions they believe are not lawful. For landlords, it emphasizes the importance of staying updated with legal developments. Because relying on outdated practices, even unintentionally, can lead to legal disputes. And this brings us to a key turning point in many cases. When a court decision or legal development draws attention to a specific issue, it often triggers broader awareness. More tenants begin to question certain practices. More landlords review their policies. And gradually, behavior across the system begins to adjust. In my legal analysis, this ripple effect is one of the most powerful aspects of legal interpretation, because a single case can influence thousands of future interactions. As we move deeper, let's examine the legal disputes that often trigger headlines like this. One common scenario involves eviction procedures. In many states, landlords are legally required to follow specific steps before removing a tenant. This can include giving written notice, allowing a set period to pay overdue rent, or resolving minor disputes. According to official records, courts have repeatedly emphasized that bypassing these procedures, sometimes called self-help evictions, is illegal. Yet, in practice, some landlords attempt these shortcuts, assuming they are permissible. When a court intervenes, it reinforces the limits of landlord power. But eviction is just one part of the picture. Lease agreements are another. Many leases include clauses that are overly restrictive or conflict with state law. For example, some may attempt to limit a tenant's right to challenge maintenance issues, privacy protections, or lawful occupancy rights. Courts have consistently held that statutory protections override any lease provision that is unlawful or unenforceable. Here's where things get interesting. Even if a landlord has never violated a law intentionally, a court ruling clarifying these rights can have a ripple effect. Suddenly, tenants understand the boundaries of their protections. Landlords must revise standard practices to comply fully with the law, and the result is what feels like a dramatic shift. But legally, it's an enforcement of pre-existing rights. Now consider the balance between federal and state law. Housing is largely a state-regulated matter, but federal law can intersect, especially in areas like anti-discrimination protections or federally funded housing programs. For example, the Fair Housing Act prohibits discrimination based on race, religion, disability, or other protected classes. If a landlord attempts to enforce lease provisions that conflict with federal protections, courts will strike them down. Additionally, some recent court decisions have clarified that constitutional principles apply even in routine landlord-tenant interactions. The 14th Amendment, which guarantees due process and equal protection, is often cited in cases involving unlawful evictions or denial of essential services. This is critical because it reminds landlords that their authority is not absolute. Legal protections exist to prevent misuse of power, even unintentionally. Let's now reconstruct a typical case chronology, based on verified patterns seen in multiple rulings. A tenant files a complaint, claiming that the landlord acted outside legal bounds, whether it's a notice not properly delivered, entry without consent, or an attempt to bypass legal eviction. The landlord responds, often citing the lease agreement or standard practices. The court reviews the statutory framework, the evidence, and any relevant precedent. Then, the judge issues a ruling clarifying the extent of the landlord's authority. It may seem procedural, but the implications are significant. Once a ruling is made, it sets a benchmark. Other tenants and landlords become aware that certain actions are either unlawful or require strict adherence to process. In my legal analysis, this is why headlines sometimes exaggerate the suddenness of change. The law itself hasn't shifted overnight. What has changed is public awareness and judicial enforcement. Now let's discuss some of the controversial or pivotal points that often arise. One key debate is over what constitutes reasonable access for landlords. States vary, but most require landlords to provide notice. typically 24 to 48 hours, before entering a tenant's unit, except in emergencies. Some landlords argue that urgent maintenance needs allow immediate entry. Courts must balance tenant privacy with the landlord's duty to maintain property safely. Another issue is the interpretation of lease clauses. Landlords may argue that a clause permitting certain actions is valid because the tenant agreed to it. Tenants, however, can counter that statutory rights cannot be waived in ways that violate the law. Courts consistently support the principle that statutory protections cannot be overridden by private agreements. Then there's rent control and eviction moratoriums, areas that have recently gained attention. Federal, state, and local authorities have issued temporary rules in response to emergencies or economic crises. Even after these programs expire, courts may look at enforcement history to determine what constitutes fair practice. Landlords who ignore these rulings risk legal challenges, even if they believe the rules no longer applied. From a practical perspective, this legal clarification has direct implications for both sides. Tenants gain stronger confidence in asserting their rights. Landlords must review all practices, from notices, entry protocols, and lease terms, to ensure compliance. Now let's examine precedent. Multiple state appellate courts have ruled that failure to follow statutory procedures invalidates attempts at eviction or control. Federal courts have reinforced that constitutional due process principles cannot be ignored in housing matters. These cases demonstrate that power in landlord-tenant relationships is carefully circumscribed. For instance, in situations where a landlord attempted self-help eviction without notice, courts repeatedly ruled that such actions were unlawful. The tenant was restored to occupancy, and landlords faced penalties. These rulings collectively shape the current understanding of what landlords can and cannot do. Another turning point often involves public awareness. Once a court issues a ruling clarifying limits on landlord power, news coverage, legal guides, and tenant advocacy groups amplify the information. Suddenly, tenants know more about their rights, and landlords face stronger scrutiny. From a legal standpoint, this is how the system ensures balance. Courts clarify rules, public awareness enforces compliance, and over time, behavior adjusts across the market. This leads to the broader implication: knowledge is power. Tenants who understand statutory and constitutional protections are better positioned to assert their rights legally. Landlords who stay informed are better equipped to avoid disputes and potential litigation. Now, before we move toward the conclusion, let's engage again with a key question for you. Do you think these legal clarifications go far enough to protect tenants, or do they risk limiting landlords' ability to manage property effectively? Share your perspective in the comments below. As we approach the final layer, it's important to focus on the constitutional framework that underpins all landlord-tenant disputes. The 14th Amendment guarantees that no person shall be deprived of life, liberty, or property without due process of law. In housing, this principle manifests as procedural protections for tenants. Courts consistently evaluate whether landlords have provided proper notice, legal justification, and an opportunity for tenants to respond before taking actions like eviction or property entry. One interpretation is that these constitutional safeguards serve as a backstop, ensuring that tenants are not arbitrarily subjected to changes or actions by landlords. Another perspective raised in court is that landlords must balance their property rights with tenants' fundamental protections, meaning that even lawful ownership does not allow bypassing established legal procedures. Similarly, the Fourth Amendment protects individuals from unlawful searches and intrusions. In a housing context, courts may examine whether landlord entry violates a tenant's reasonable expectation of privacy. For example, entering a unit without proper notice, even to perform routine maintenance, can trigger legal scrutiny. Federal courts have weighed in on these principles repeatedly, reinforcing that state laws governing landlord-tenant relationships must comply with constitutional safeguards. This creates a layered framework. Statutory protections set the rules, and constitutional principles ensure fairness and due process. Now, looking at the real-world impact, what does this mean for tenants? Tenants now have clearer legal grounds to assert their rights, prevent unauthorized entry, and challenge eviction attempts that do not follow proper procedures. This creates a stronger sense of security in their homes, as they understand the limits of landlord authority. For landlords, the message is equally important. Legal compliance is not optional. Understanding both statutory and constitutional obligations is essential to avoid disputes, potential penalties, and reputational risk. Landlords must review leases, entry policies, and eviction procedures regularly to ensure alignment with current law. Another dimension is the long-term effect on housing law. Court rulings clarifying tenant protections often influence future cases, creating precedent that shapes landlord practices nationwide. What might start as a single tenant's challenge can gradually redefine the boundaries of property management, ensuring fairness and accountability in the system. It's also important to acknowledge differing perspectives. Supporters of strong tenant protections argue that these rules prevent abuse, unlawful eviction, and preserve housing stability. Critics may contend that restrictions complicate property management and increase administrative burden. Courts, through careful interpretation, strive to balance these competing interests while upholding the law. In my legal analysis, the key takeaway is this: legal change is often less about sudden reform and more about clarity, enforcement, and judicial guidance. Headlines may make it seem like landlords suddenly lost power, but what actually happened is that the system clarified boundaries and reinforced protections that have long existed. Now let's bring it all together. We began with a question. Landlords can't do this anymore. But what does it really mean? It means that statutory and constitutional protections have been reaffirmed and clarified, giving tenants stronger legal footing while reminding landlords of their responsibilities. It also illustrates a broader principle in law. Knowledge and awareness are essential. Understanding your rights, obligations, and the legal framework ensures fair outcomes for all parties and reduces conflict. Before we close, here's a final question for you. Do you think these clarified tenant protections strike the right balance between tenant rights and landlord authority? Or is more reform needed to make housing law fair for everyone? Share your thoughts in the comments below. If you found this breakdown valuable and want more professional, fact-based legal analysis, make sure you subscribe to the channel, press the bell icon, and turn on notifications so you don't miss our future videos. And don't forget, tell me in the comments what topic you want us to cover next. Your suggestion might be the focus of our next deep dive investigative video, because in the world of law, understanding is power. Headlines tell you what changed, but only knowledge tells you why it matters. Remember, stay informed, act responsibly, and always know your rights.